Yeah, Judge looks very festive today.
So this is an FSGI, am I right?
Yes, sir. Hola, yo te voy a interpretar, ¿ok?
Good morning, Ms. Reyes.
Sean Díaz, señora Reyes.
Good morning.
Ms. Reyes, you're charged with failure to stop and give
Acusa-
information,
Información.
Okay.
essentially leaving the scene of an accident
Básicamente,
without exchanging information.
Escena de un accidente sin intercambiar la información que necesitabas hacer.
You were facing up to 180 days in jail
180 días en la cárcel por
and or a $2,000
una
fine.
multa que no sobrepase $2,000.
We are going to do probable cause.
Soldados,
You have the right to remain silent. Anything you say can or will be used against you.
contra usted.
I insist she stay silent.
Y tu abogado insiste que se quede callada.
Just please go slow.
Yes, Your Honor. On March
El
10th,
10 de marzo
2025,
del 2025,
officers were
los
dispatched to
oficiales
Safer
fueron
Street
a
and
una calle Safer
Seth Street in reference to an
Street.
FSGI.
bajo una referencia de faltar y dar información.
The officers were
Los
advised that a white Charger
oficiales
left the scene
dijeron que
following
un
an
White Charger
accident
se fue de la escena después de un accidente
and was last seen
y
going
lo
southbound
vieron
on Shaver
y iba
Street.
por en camino al sur en la calle Shaver.
The complainant stated that she
quejante
was
dijo
traveling when a
que ella
white
estaba
Dodger
manejando
made a
cuando un
unsafe lane
Dodger
change
Cambió de carril, pero sin
and collided with her.
y chocó contra ella.
The complainant
El
showed
quejante
officer a
dijo,
picture of the
Él
suspect
tomó
vehicle,
una foto del vehículo y le enseñó
Which
al oficial
showed the license
y
plate
tenía la
and
placa.
damage to the vehicle
y
on
el
the back
daño al
left
vehículo.
portion. The complainant
El
estimated that the
quejante
damage was
dijo que
around
él
$1,000.
está estimando que costó como $1,000 en reparación.
Officers ran the
Y los
vehicle and
oficiales
found the registered
Vieron la
owner to
placa
be
y
Juan Maneno.
encontraron que el dueño era Juan Veneno.
The officer located the vehicle at the apartment complex
Encontraron
that the
el
vehicle was
vehículo
registered
en
to.
los apartamentos a donde estaba registrado.
The officer met with
Y
Juan
el
and his
oficial
wife, who is
habló
the
con Juan y
defendant.
la esposa, que es el acusado.
Juan advised the officers that the
Y Juan
defendant
le
had been
dijo
driving
que
the
el
vehicle all
acusado
day,
estaba
and that
manejando
the
todo el día el
and
vehículo.
that the only damage to
que
the vehicle should have been on the
daño
front bumper from a
que tenía
previous
el
incident
vehículo
and
era
nothing
en la
else.
parte de frente de un accidente previo.
The defendant advised
el
officers
acusado
that she was
le
driving the
dijo
vehicle and
que
had
ella estaba
recently gotten
manejando
back from a Walmart,
El vehículo y había regresado
which
de
is around
Walmart
700
como
feet from
como
where the incident
700
occurred.
pies de a donde ocurrió el
She denied hitting
incidente
anybody.
y ella negó pegarle a cualquier persona. Negó que
Your Honor, so based on the
y basado
information,
en la
the
información dice
car was registered to his wife.
So, how do we know who's
And
driving
the
it?
complaint,
y
the
cómo sabe quién
Juan
está
stated that
manejando.
he was the one driving and she admitted to being in that location at the time.
She denied hitting, right? Do we have any kind of evidence that puts her at the scene that she's the one that causes the accident?
Que ella estaba ahí y causó el accidente. Go ahead.
That she
Sí.
was the one, within 700 feet of the accident and that she had
Estaba
access to the vehicle, Your Honor.
Tenía acceso al vehículo y estaba a 700
And this
pies
vehicle was the one that was in the
del
accident.
lugar. Y ese fue el vehículo que causó el accidente.
Did you say that the husband said that she was driving it?
She was driving
El
it all day.
esposo
Your Honor.
dijo que estaba manejando.
statement.
Dice que sí.
Do you want to add anything? Did you want to say anything?
No, well,
Yeah,
two
yeah,
things,
yeah.
Judge. Number
Dice
one, there
dos.
was no evidence that
No hay
she was,
evidencia.
as you mentioned, there was no evidence that she was
Que ella
driving the
estaba
vehicle. And just because she had the vehicle all day does
Solo
not mean she
dice
was
porque
driving
tenía
it.
el vehículo ese día.
For example,
No
when I'm sure my
significa
daughter's
que estaba
home,
manejando.
I'm sure,
Porque cuando,
and she's
por
using one of our
ejemplo,
vehicles, I'm sure that
mi hija
her lunkhead
está usando,
boyfriend is probably driving it the majority of the
vehículo
time.
puede ser que
Additionally,
el
this
novio de
vehicle
mi hija
is
estaba
insured.
manejando. Ahora el vehículo está-
There's never been
tiene
any
está
report of
asegurado.
anyone, but
Ningún
people had
reporte.
consent to driving it. That defense is not going to be erased, so this is
Y
an
eso-
insured incident.
It's just,
Es un incidente
you got A, you got C, but you don't have B. I mean, I just don't think that,
A ver,
officer could have gone to Walmart, pull video, see her coming out, other
pueden ir a Walmart a ver si
cameras anywhere else. I don't know, but I just,
no hay
I
prueba.
don't think there's enough.
Okay,
You know?
stressed.
All right, I'm gonna find no probable cause in your case,
Va a
ma'am.
encontrar que hay motivos fundados para mantenerte.
Please be careful when you're driving.
Por favor, ten cuidado con
If you're going to drive, do not drive unless you have a valid license
no manejes.
and liability insurance in your name.
Y seguro.
Do you understand?
¿Entendido?
Okay, all right.
And she does for the court's edification.
Thanks, Jen.
Always great seeing you, and I apologize on the record for calling it my future son-in-law's a lunkhead, in case that goes anywhere. I forgot it's being videoed. All right, take care.
Hey everybody, welcome to American Courts. We got some Judge Mogan and Judge who else we got? Oh, we got hell, it's been a long day. I've already forgot. Oh, we got Judge McNally and another one from Judge Fleischer. So we got a pretty good little show. We were trying to get Judge Simpson today with the non-lawyer lady, but she didn't show up for court. It got it rescheduled. Something's coming up on April 8th, so that'll be our next bet for that. We're going to let's go ahead and jump over to Judge McNally. This one was earlier in the week. I wasn't able to show it, but it's certainly worth showing. So here we go with that.
Is Ms. Johnson here? There she. Yeah, there you are. Ma'am, you have to unmute and state your name, and then Trooper, state your name, please.
Trooper Weston Williams.
Crystal Johnson.
All right. Any offer here, Trooper?
Is this for Mr. Ali?
No, it's for Crystal Johnson. This is a violation of basic speed law. So she slowed off the roadway into the woods due to a snowy, wet condition.
Yeah, I'd offer impeding traffic.
Do you want to plead to impeding traffic, ma'am?
No, sir, I do not.
Okay, so I want to just have you listen to me a second here, and then we can go from there, okay? It
Absolutely.
doesn't matter. It doesn't matter to me whether you take impeding traffic or not. We have a hearing that can take place right now by Zoom. Violation of the basic speed law requires you to keep your vehicle under control at all times, no matter the road conditions. So if, as an example, I determined that you were traveling and you drove off into the off the roadway, that would be a violation of the basic speed law. I'm not trying to talk you out of having the hearing, but if we have the hearing and you lose, you're going to get the points. So but I'm not under any circumstance trying to talk you out of having a hearing.
I understand.
So do you want to have the hearing still, or do you want to plead to impeding?
I want to have the hearing.
Raise your right hands. Trooper, I need to see your hand, please. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. Trooper?
Yes, sir.
Ma'am?
Yes.
Okay, you can proceed, Trooper.
I'm on a crash right now, sir. Do you mind giving me 1 second here? My partner.
No, take your time.
Real quick.
Pardon?
My partner's going to kick these occupants loose, and just give me 1 second here. I apologize.
No problem. Do you have any questions about what I said, Ms. Johnson, before we begin?
I do not.
All right, I've got a few questions. So she got charged with violating the basic speed laws in Michigan. It basically says if you lose control of your vehicle, you violated the rule and you can get a ticket for it. And so if you're driving on snow and you slide off the road, you got a ticket. That's what she's fighting on this. And so they tried to give her I think it was $100 and no points. And she's arguing it, wanting to fight it, and willing to risk the points. So here we go on that.
Okay. Do you have Marissa Sedlar here, Lisa?
2022-54.
Go ahead.
They saw mine over the wall, blocking the left lane and causing a major backup. Or see what's going on. I can't get any cars.
Yeah, did he?
He says,
I agree with you
can
on that,
hear me?
man.
Is Marissa Jade Sedlar out there?
Yes, she is.
Why don't you bring her in, and that'd be Trooper Pusilowski.
He's not here on Zoom.
Okay, people against Marissa
Yes.
Jade Sedlar, 25M493-218. Your name, ma'am?
Marissa Jade Sedler.
Good morning to you.
Good morning.
The officer failed to appear. I gave him 15 minutes. Case dismissed.
Okay.
Okay, you're all set. Have a good day. Be careful out there. Good luck.
Awesome. Thank you. Have a good day. Bye-bye.
You too. All right, recalling Crystal Ann Johnson, 25M491-844. Trooper, your name again?
Trooper Weston Williams.
Ms. Johnson, your name again?
Crystal Johnson.
I've had you both sworn in. Trooper, you can go ahead and proceed.
Yes, sir. On 2/15/2025 at approximately 10:39 in the morning, I was dispatched to a crash. It was a one vehicle crash. The driver slid off in the right ditch. It was snowy conditions that day, and I wrote her a citation for a violation of basic speed law.
And that was Ms.
South
Johnson?
75. Yes, sir. That was South 75 near Gibraltar.
Sibley.
Okay.
Or Sibley. Sorry about that.
Okay. Any questions of him, Ms. Johnson?
I have no questions, sir.
Do you wish to testify?
I do. I actually wish I could be in court right now, but obviously Trooper Williams isn't there, so it wouldn't matter. He arrived an hour after the situation, so I would like to state that. Therefore, he had no idea what the conditions were of the roads. I would like to state that I drove 34 miles without incident before sliding off the road. So clearly I was not driving erratically if I made it 34 miles in a snowstorm. I printed out pictures of what the conditions were. You can see his vehicle right there.
Ma'am,
Yes.
before we go on, I'm gonna listen to you.
Okay.
I'm not gonna be a legislator here, though. I didn't write this law. And it says what it says. And
Understood,
that
sir.
is clearly a violation of the basic speed law. I'm trying to help you. I'm not trying to hurt you. I'm not trying to cut you off. I'm not trying to be mean or any other such thing. This was a technical violation of the basic speed law. I cannot do anything but find you responsible. If you want to take the impeding, you're going to save yourself 2 points. Now,
Sir?
I'm going to listen to you. I'm not going to debate it with you. I'm just trying to tell you again nicely, and then you can tell me, Judge, I want to proceed, or Judge, I want to take the plea, and I'll shut up and listen.
Okay, Judge, I am wanting to proceed.
Okay, go ahead.
Thank you.
Go ahead.
And the reason I am proceeding is because there was no speed violation whatsoever, as I made it 34 miles without any issue or incident. The officer or you're not listening, so this is great. You're as great as the trooper is. And I would like it on.
Whoa.
No, I want this on record that this is what the problem is, and this is why I did not want to take the impeding traffic. The officer mocked me. The officer made sure to belittle me. And I refuse to allow that kind of treatment.
Okay.
So that is where I'm
anything
coming
else?
from. That would be it, sir.
I want to make sure that you've had full opportunity to tell me everything.
No, I haven't, because you have made it clear that you do not care to listen either. And it is okay. I have gone through the chain of commands that I need to, and I will continue.
I could tell you had a chip on your shoulder from the get-go. You know that?
Oh, thank you.
I'm trying to help you here, and And you want to make your own, you want me to make my own laws, and that I
What
can't do. I
no,
just
you're not
asked,
making a law.
hang on. I asked to see your record. That's all I said. Do not accuse me of not listening. I heard every single word you said. If there's anything else you want to say, go ahead and say it. I'm all ears. I'll listen to whatever else.
Okay, I'm going to speak now then. Is that okay?
No, it's not right now. Trooper, did you mock her in any way?
No, sir. So she filed a complaint against me to my post commander. He sent the video up to our internal affairs who investigates complaints, and they didn't find anything wrong with the interaction we had. The only thing that was wrong, I wasn't wearing my hat.
You were
That's the only
wearing
thing
your
I got.
hat, sir.
That's what I told them, but I wasn't wearing it for the whole time. So that's what they talked to me about.
Mm.
I didn't get in trouble for anything else of how we interacted with each other. So,
All right, go ahead, Ms. Johnson.
So when he asked me if I was speeding, I told him I was not, and he gestured to the people driving down the road and said, well, none of these people are flying off the road. To me, that is mocking me. I had been through something traumatic, and for him to say something like that and compare me to people is absolutely sad and not okay. Period. And it went downhill from there. It's not that I have a chip on my shoulder. I showed him the utmost respect. I tried very hard to be very kind until that moment. Then I told him I did not want to speak to him anymore. And he continued to follow me. And I don't feel as though that kind of treatment.
Imagine being on the side of the road with a police officer and you tell the police officer, I don't want to talk to you anymore, and you just want to go to the corner. I couldn't imagine. It seemed like the beginning of a good Biggin episode.
Basically, victim shaming people is the way to handle yourself as an officer. I went home and had a conversation with my 21 and 16-year-old to let them know, do not call the police if you are ever in trouble. They do not care.
Yeah, that's good to tell your family.
It was awful. It was a bad situation. It's not a chip on my shoulder. It's me being hurt.
All right, listen. Okay. Anything else?
That's it. Just that it was a
I want you to understand. I want you to understand. I would never condone anybody talking to anybody in a demeaning fashion.
Well,
okay?
It was.
Well, but that doesn't entitle you to a dismissal of the case. I tried to tell you nicely. I tried to tell you 2 or 3. I mean, I don't have any choice but to find you responsible as charged.
That's fine.
I really wish you would have taken the impeding. I really do.
That's fine.
135 is your total. Can you pay that today, or do you need time?
I can pay that today.
Okay, you can go online on 33court.com.
Thank you.
Good luck to you, ma'am. I wish you well.
Yeah.
Thank you.
Yeah.
All right, I am not mean, Critter. I've seen you. Thank you for coming out to the show. I'm glad your work cooperated with you tonight. I really appreciate it. It means everything to me to have you here. We even got Donald here, so Donald's here to say hi to you. Thank you, everybody, for coming out. Let's jump to Judge Mogan. This is a violation hearing. She's got a great one. But I'm gonna save that one for the last. It's a little bit longer, but it's a really good one. So let's do the violation one.
We will go on the record in the matters 20 CM 234, 21 CF 130, 21 CM 199, State of Wisconsin versus Benjamin Flannery. The state appears through DOC agent Leah Lineweber. We have Mr. Flannery in person as well. We're set here today for a probation review hearing. We were here on February 19th, in which the court did provide specific orders and conditions for Mr. Flannery to meet to avoid having conditional jail. He was serving some conditional jail or in custody on a warrant and facing conditional jail. At that time, the Department of Corrections had another individual, Gretchen Anibis, in your place, Miss Lineweber. That is not the agent of record. You were on vacation. And so she had notes about the case, and there was a recommendation from your standpoint and Department of Corrections standpoint. But now you are back from vacation and you can provide the court with an update on where we are now from February 19th and where Mr. Flannery is as and if he is actually meeting the conditions of the court.
He is not meeting the conditions of the court. He showed up on the 28th of February and he admitted to using methamphetamine.
I'm sorry, I have to turn you up a bit. Go ahead.
You want me to repeat?
Yeah, no, you don't have to repeat, but can you bring the microphone just a little bit closer?
During that office visit, he was told about the GED boot camp. He did fill out the paperwork while he was in the office and we did email it to the GED boot camp to make sure it got there. He did come back on the 14th and he was positive for marijuana and he stated that it was not new use. But I did not realize at that time that he didn't test positive or he didn't admit to it when he came into the office the first time. So I believe it was probably new use, but he was negative for methamphetamines at that time. He has not handed in any of the job logs, but he did state that he was hired full-time with his wife's uncle, I believe. He was told that he needed to bring in documentation, like fill out the days and the times and have the boss sign it, verifying that that's what he worked. And he was supposed to bring it to court today. And he has not.
Okay. Mr. Flannery. All right, so you were here in court on the 19th. You then saw your DOC agent on the 28th and you admitted to consuming methamphetamine, correct?
Correct.
So from February 19th, in which you were in court and the court set very strict conditions and did not order conditional jail, you used methamphetamine between February 19th and February 28th. Correct?
Yep.
And then between February 19th and March 14th, you used at least you used THC marijuana, correct?
Correct.
Now, I have a notation that you've paid in your probation cases. Is that correct? Have you made any payments?
Yeah.
When did you make payments?
I made, after the first 2 weeks, because you said $50 a week. After the first 2 weeks, I paid 100. I paid 50 last week, and I have 50 this week, Friday.
All right, but you still owe a significant amount.
Yeah.
All right, you understand one of those conditions that the court did order was absolute sobriety. Understand that?
Yeah.
I mean, that is one of the conditions, not only that is part of why you were not ordered for conditional jail on February 19th, but that is one of the conditions for your probation. You understand that? Understand that?
Yes, I do.
Okay. And so now we have two admitted uses of not only THC, but methamphetamine. And we're talking February 19th to February 28th is not that long in time, right?
Right.
Ms. Lineweber, is there a recommendation from Department of Corrections?
There was not.
You don't have a recommendation?
No, I'm sorry. I just assumed we would bring it to you and then you would decide what you wanted to do.
Mr. Flannery, is there anything that you want to tell the court or you want to let me know?
Yeah, I mean, the drug use, I guess I understand it was a rule that I broke, but it was more of a slip up and I'm doing pretty good.
Your eyes look kind of bloodshot right now.
Yeah, it's windy and cold. I've been outside all morning.
If I get you tested right now, you're not going to test positive?
No.
Okay. What else?
Well, now that I've been working full time, I can make my payments for sure.
And who are you working for?
M5 Construction is the company. His name's Kevin Miller.
Oh, I know Kevin Miller.
Yeah,
And who is he to you?
he's my uncle-in-law.
So I have one memorandum from the Department of Corrections from March 17th. I had another memorandum, but I don't know which file that was filed in. But I do remember there was another one filed from a different date prior to the last probation hearing. At least I thought there was. Maybe it was just what Ms. Annabus told the court. Did you file a memorandum prior to the last hearing?
I did, requesting the hearing.
Requesting the hearing. Do you remember what date that was?
I do not, I'm sorry.
Oh, that's okay. Oh, was that in December?
It very well could have been.
Yes. December 23rd, 2024 was a memorandum requesting a hearing. He wasn't paying his fines and fees. He didn't get his GED. He didn't complete the AODA. Oh, that's another reason. That's what we discussed, the AODA last time, and with the absolute sobriety. All right, anything else that you want me to know, Mr. Flannery?
I guess not.
All right. Well, based upon what occurred on February 19th and based upon what occurred between February 19th and today, the court is going to order 90 days of conditional jail to start immediately today. You'll be taken up right now. 90 days conditional jail.
Can I get one more?
Nope, you're all done. I gave it to you on February 19th. You're all done. 90 days.
Come on, I'm just getting my
90
stuff
days.
together. I've been doing,
I gave you leniency on
give me
February
a chance
19th.
at least to,
I gave you a chance
I
on
know,
February
but
19th.
please, come on,
I
please.
gave you your chance on
Judge,
February 19th.
please.
You have not done your AODA since I sentenced you, Mr. Flannery.
You said
did I
about the
sentence you?
AODA,
When did I sentence you?
you said about AODA, remember you said we're gonna just put that aside right
If
now and worry about the
you're
other stuff.
clean.
We'll worry about the other things. Okay, so I'll
you were
do the
clean and
AODA.
sober. Nope.
I'll do the AODA then.
90 days.
I'm
Bring him
signed up
upstairs.
to do my
We're
GED.
adjourned.
Your Honor, please, come on.
90 days.
No. Come on, please.
90 days. 100 days.
What?
You just swore. 100 days.
Well, that causes me to lose hope. My son acts like that sometimes, but he's never let it go that far, and he damn sure wouldn't act like that in front of a judge, or hopefully he wouldn't. Hopefully he wouldn't. I don't put anything past him. All right, so let's go to another Judge Fleischer one, and then we will jump to another Judge Mogan one, and this one's a little bit longer, but I think it's got every little bit of a story it could. It does talk about self-harm in it, so be careful with that if you got any trigger things with that, but she did damn good on it. So here's Judge Fleischer.
Good morning, Mr. Ibarra. Good morning, sir. So you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, this is a under 21 UCW. I can still read you the facts if you would like. Okay. On March 3rd, 2025, an officer was dispatched to a shooting. The officer found the defendant in a back alleyway with a gunshot wound to his leg. The defendant had a mesh backpack in his possession at the time and was able to see that there was a black handgun inside. The caliber of the handgun matched shell casings located on the ground next to the defendant. The defendant stated that he shot the gun in self-defense at 3 black males who shot at him. Those suspects fled the scene after officers' arrival. The defendant was transported to Ben Taub Hospital, where the defendant was being treated for the gunshot wound to his left femur. The defendant admitted to being in the 114th Street Bounty Hunters gang and is 18 years old.
Okay, so was it really that, did he shoot himself, or do we know that someone else shot?
We do not know. We
So-
know that the casings on scene match the caliber of the handgun that he had, but we don't know if he had shot himself and he stated he was being shot at by other people as well. So it's unclear.
So the only allegation is that he's underage, essentially. Okay. Mr. Ibarra, I'm going to find that there's no probable cause to go forward in your case. You need to be very careful. You get but one life. You know, God forbid something happens where you have a gun and you use it, and then you end up getting charged with something. You've gotten shot in the leg now. I mean, luckily it's not somewhere else. It could be life ending.
Sure.
When you hang with dogs or when you're bad places in the middle of the night, really, do something with your life. Get into school, graduate, get some knowledge.
So
Take a seat.
It says that's funny. I'm a gun guy. I like my guns. I enjoy them. I'm all about self-protection and all that. But I can almost assure you that I'm more scared of shooting myself than I am of getting shot by somebody. I don't know why. I think it's just you play around with them long enough and something happens. But certainly not something I want to do. So, all right. Let's see. Oh, thank you, Casey. I appreciate that. We support all channels here, but we certainly like our channel. We're proud to have it here. Let's go to Judge Mogan again. She had this one's kooky as hell. This one, she's sentencing a guy, and I think he lies about everything. I think he'll give her every answer and just see if anything works for her. So let's see what we got there.
We will go on the record in the matter 23 CF 213, State of Wisconsin versus Bradley Scheuer. This state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Scheuer appearing in person in custody with counsel Glenn Keene. We're set here today in this matter for a sentencing hearing after revocation. Mr. Scheuer was placed on probation after he pled guilty back on September 3rd, 2024 to one count of possession of a firearm by a convicted felon. 3 days after he was placed on probation, he was put into custody for another serious offense in which he was just recently sentenced. He was revoked on this matter due to the allegations and matters in the case that he was just previously sentenced. This matter was set for a revocation sentencing. The court has received and reviewed the revocation order and warrant packet from the Department of Corrections. I have reviewed such packet, and in my review, I could not see any material facts or statements that need to be clarified on the record. But again, I don't know all of the information that the attorneys know to be able to have those material facts and corrections jump out at me. Ms. Rockow, as Assistant District Attorney, are we in victims' rights compliance?
Yes.
Did you review the revocation order and packet in order?
I did.
Any material facts or statements that need to be corrected on the record?
No, Judge.
Is there going to be a victim impact statement made here today?
No.
Okay. Mr. Keene, did you receive and review the revocation order and recommendation packet?
Yes, Your Honor, and there are no facts in there that I believe need to be corrected.
Did you review that thoroughly with Mr. Scheuer?
Yes, Your Honor.
And he did not discover or find any material facts or information that should be corrected on the record?
But no, Your Honor.
Okay, all right, thank you. Ms. Rockow, please begin your sentencing argument and recommendation.
Thank you, Judge. The state respectfully recommends that Mr. Scheuer be sentenced to the state prison system for a total of 4 years, with 2 years of initial confinement, 2 years of extended supervision. That is in line with the recommendation that was outlined in the PSI by the department. As the court's aware, we are to consider the Galleon factors here in determining an appropriate sentence for Mr. Scheuer. The state's position is that Mr. Scheuer must be sentenced to prison based upon the factors. As far as the gravity of the offense, possession of a firearm by a felon is very serious. The legislature indeed has deemed this a Class G felony with a maximum possible penalty of 10 years. It's a crime that poses a serious risk to public safety. This crime in particular, the underlying facts of this case warrant a prison sentence. Mr. Scheuer was at sentencing. There were 4 other counts that were dismissed but read in, including 3 counts of possession of a firearm by a felon in addition to this conviction. There were 4 total rifles that were in Mr. Scheuer's possession at the time of this incident. And on the date of that arrest, he admitted, and in fact, one was in his direct control, very nearby to him, and he had admitted to law enforcement to having handled that firearm in particular on that date. He also had a knife concealed in his possession. So this is an inherently serious crime, and the facts are also quite serious in this case. In terms of the character of the defendant, again, inherent in this crime is an indication that the defendant has no regard for the law. He's a convicted felon, not allowed to possess firearms, and he did so anyway. His criminal history reflects convictions dating back to the early 2000s. He has a fairly extensive history. His history does include violent offenses, convictions for battery, simple battery and substantial battery, violations of domestic abuse, no contact orders, also includes recklessly endangering safety, and multiple convictions for bail jumping. I'll also note that there's a 2014 conviction out of Minnesota for possessing a pistol or assault weapon. The need to protect the public is the last factor for the court to consider. And I think that there's an obvious need to protect the public from Mr. Scheuer. A convicted felon with a violent criminal history who shows no regard for the law, no regard for court orders, or for the public, or for public safety. His actions that led to the revocation obviously include more violence, more disregard for public safety and for the law. I think anything other than a commitment to the state prison system would unduly depreciate the seriousness of the offense and the conviction here. And I do think, in fact, prison is necessary to protect the public in this case. Thank you.
All right. Mr. Keem.
Your Honor, I do have one character witness for him. It's his son, Brandon Scheuer, who's here in court.
All right, Mr. Scheuer, you can come have a seat over at the black table, and you can state your name and spell it for the record.
Hello, hear me? My name is Brandon Scheuer. It's BRANDON SCHEUER.
You may begin.
Where do you want me to start? Glenn?
Oh,
Nope, you just.
whatever you talked about.
Oh, whatever to talk
Yeah.
about.
Yeah.
All right, well, I'll start off by saying that, I do think that violent criminals should be in prison. I don't think my dad's a violent criminal. I think that he has mental health issues that were never addressed for the last 20 years. And I do believe alcoholism amplifies those. And I believe getting mental health would help him dramatically. In the case of this issue, I could tell my father was a different person after the suicide. My father always had like a clean counter, dishes always done, up early. I would not hear from him for a couple of days after the incident. I would go check on him. He would still be in bed with a giant body pillow, counter trash, sink full of dishes, just completely not his character. And I believe that was just more depression. And I think that his depression and his mental health issues have never been addressed. And he's constantly been incarcerated and never gotten help that he's needed. And I think getting him the help he needs is a big step. Is he going to have to be in prison? Yes. But just locking him up isn't going to help him. He needs to get help. And I wish the court system would help more people in this case. It's an epidemic in this country where people are just locked away when they have issues and we don't address the mental health issues that we need to address. 3 of those guns that were locked in the shed on the day of that incident were mine for deer hunting. I had them locked in that shed. I believed I had the only key to that shed. I was unaware there was a second key. The .22 firearm that was used in the incident, to my knowledge, was used for protection against bears as they were living in my camper on his 40 acres. When Crystal and my father first started staying on the 40, they were staying in a tent. They had bears tear the tent, tear the coolers. I gave them my camper to stay in as a safety option. Other than that, the only real things I have to say is that I believe that this country has a problem with just locking people up and throwing them away. And I think that we need to address mental health issues more and more in this country. And this case in particular, he's had 20 years where he's never had that addressed. And he grew up at a time where when people had mental health issues, they really didn't talk about it or get addressed. And I believe most of his issues stemmed after the divorce with my mother in 2003. His alcoholism, which he hadn't drank in many years, had kicked off and came back into his life and continued to amplify those mental health issues. Because when people are depressed, the drinking don't help that. All it does is amplify those issues. And that was never, ever addressed in over 20 years of him being in and out of the system. That being said, I can't quite think of too much other things to say. I know my father is a very good person when he's not drinking. He has donated his time to my business during the parades and other things, and to help me with working with kids in the community for kayaking. He cuts and splits wood. He has helped friends of mine who needed trees removed or other things on their property done come over without even being paid to help out, just to be a good Samaritan. So I know there's good in him. We're not unlocking the good. We're locking the good up with the bad. Where we should lock the bad up and unlock that good. And the only way that is to use, mental health therapy and other sorts of programs to get to the root of the problem. I went through therapy because of you, Judge, and I continue to do that therapy for a while after the things we had with the things I did to get back, and it helped me very much. I'd come creating new programs to help myself hydrate more, things like that, getting better eating schedules, just slight things to add more consistency to life and a more routine schedule. And I think, that helps a lot of people. And it's something I needed just slightly to help my life. But there's a lot of people that need a lot more than that. And they need that intense mental care. And that's something this country has gotten far, far away from. And I hope we get back to it.
Thank you, Mr. Scheuer.
Thank you, Your Honor.
All right. Mr. Keen?
Yes, sir. When we look at this case and sentencing and the factors, I think a couple of things to note. Well, I won't dispute the seriousness of the crimes because Mr. Scheuer does have a lengthy criminal record. Most of it is for, substance abuse related issues, but you've seen it on pages 24 and 25. So, I won't dispute that. However, when you look at the character of the defendant, I would note that when you look at the offenses that day, his son had just talked about how, the 3 of the firearms were his and it was, a place to hunt in the 40 acres. And he said that they were encased. I would note that my client on the day he was charged, had contacted law enforcement. He, pointed out, the weapon was not in, was set by the vehicle when law enforcement arrived. He's not brandishing it. And his son had just testified that the .22 was, for, protection for bears. A .22 isn't usually a weapon if you're going to try and rob somebody, a .22 isn't your first choice. And regarding the dismissed and read in on the concealed knife, I mean, it's a 40-acre property and, you know, he had it. There was nothing about him threatening to use it.
But I'm hearing excuses. He's a felon. He's a felon, a convicted felon, and I'm hearing excuses. Even in your defense argument, they're excuses.
You know, I see them as mitigating factors rather than excuses.
There's other things to use to protect against bears. I've done it myself. I've grown up in bear country myself. I don't carry a 22 or a knife. There's bear spray. There's crossbows. There's other things that felons can use and carry. It's an excuse.
Well, and these guys, the firearm was owned by the person who lived there, not him. But I get that when you live with you're a felon, and the person you live with has a firearm, it, you know, tends to put you in an untenable situation.
And he admitted to operating it.
Right, moving it. Yeah, okay. But I think we did point out in needs is that, you know, the alcohol and counseling needs, and he did talk about one of the things looking at revoked is that unfortunately, mental health needs did increase after that because his son did describe a change in my client's behavior after his then girlfriend, unfortunately, you know, took her own life that day. And, you know, that obviously contributes to a downward spiral as well. And I would note that, you know, when you look at protection of the public, I would note that, you know, he already, you know, for the offense he was, you know, convicted, you know, pled to in this court, he already had a 9-month sentence. And I think that, you know, allowing him to be closer to his son and the community would probably do more in the long term to protect the community than than just simply warehousing him again, which is what his son was saying. Because, you know, it access to, you know, counseling and other needs. So the offense thinks that, you know, a reasonable sentence would be 9 months of custody, you know, because he already has a 9-month sentence in 24 CF 202. So if you sentence him consecutive that, then he's still closer to his family and other things, and hopefully could address his needs. And, you know, if he qualified for Huber, he'd be in a confined setting, because obviously if you're, you know, having to go to and from jail or report on monitor, that would be a way of ensuring sobriety, because it, you know, that when for the charge he was revoked, he admitted to having alcohol that day. So having additional time where, you know, if he qualified for Huber and in the community, he could, you know, potentially get counseling. He could be working. He would be monitored on a continuous basis to ensure that he's not having access to alcohol versus just, you know, adding more time to prison. Then when he gets out, it's back to the same supervision that obviously hasn't worked. So I think if you look at those two sentences, you know, because they're both really the same action, you'd be looking at 18 months total custody he would have had. And I think that would promote more to protect the community while reflecting on the mixed character of Mr. Schuer than just simply, you know, tacking on a few more years in prison. And failing that, obviously, would ask that he at least be eligible for the earned release program and substance abuse. Take care. Well, I'm saying is if you disagree with our suggestion, obviously one of the decisions you'd have to look at is whether or not he would be eligible for.
He wouldn't be eligible for the challenge incarceration.
No, I'm talking about, no, I'm not talking about challenge incarceration.
For the substance abuse.
Right, yes.
Right. Okay.
Right, no, I'm aware that, you know, he's 2.5 decades too old for challenge incarceration program.
All right. All right, thank you. Mr. Scheuer, now is going to be your opportunity to tell me your side of the case, if you wish to. Anything that you would like me to know about this case, about this matter, about yourself. I have read the department's revocation packet, which does include a lot of information, and it includes the decision by the ALJ, the alternate, or the administrative law judge, and the revocation, as well as a few bits of other information. You can tell me whatever you wish to tell me right now, or you don't have to tell me anything.
Well, I'm gonna tell you one thing, that the gun was for her, it wasn't for me. It was for her protection. She was a girl from the cities and she was afraid of the bear. The gun was given to her for her own protection. And it was supposed to be locked in her storage shed, and she had the only key for that storage shed. I don't know how the gun got, obviously she went and got the gun, plain and simple. I didn't know, I was at work. And she dropped me off because I worked at the 10th hole. And she dropped me off, and then she picked me up. And then when we went home, that's when she went in and brought the gun out, plain and simple. But otherwise, yes, I myself believe I have post-traumatic stress. I was in shock. I never would want to witness anything like this in my life again. I feel sorry for Betts going to war and watching people die. I love that woman. I loved her to death. And I moved the gun till the gun fell on her. It's the only reason I moved it. I didn't know if she was going to shoot me. I didn't have a clue. It's the only reason I moved that gun. And the other guns I didn't know nothing about. Yes, I had a key. I had a key in my key ring, but I hadn't gone into the shed. I wasn't in the shed for days. And it was 2 days before deer hunting. That's all I know. And the guns that were in the storage, in her storage shed. And I know my son deer hunts, and he was supposed to have friends come over that didn't have guns, and they were going to hunt. There was no bullets, nothing there. There was absolutely nothing to fire out of them guns that were in that shed. Absolutely, there was just guns. That's all it was, guns and gun cases. And I knew nothing about them. I knew about the 22 that she had because she asked for permission, and she got the gun from my son for her own protection when she was there by herself. That's what it was supposed to be for. And like I said, I only moved the gun when she shot herself and hit the ground. That's why I moved it, and I leaned it up against the car that was in front of it. Like my son said, I help him a lot. I help a lot of people. If you even ask the jailers here, I'm cleaning all the time. I ask to move to different cells just to go clean them because they're not clean. I help a lot of people. I buy canteen for people. I'm not a violent person. Yes, I do have mental issues. And with that, yeah, I probably have drank. I started alcohol. I was sober for 24 years. My kids grew up with a sober father because my father was an alcoholic. So when my kids grew up, I didn't drink. But when my wife divorced me and I ran through the coals, I started drinking. That's when I started drinking in 2006. If you look at the records, that's when all my problems started. And with that, that's all I got to say. I wouldn't harm anybody. I wouldn't kill anybody in my life. Like I said, I wouldn't want to go to war. And with that, it's...
How many sheds were on that property?
Huh?
How many sheds were on that property?
One.
I just got multiple stories about the key, or who had keys and who had access with that. First, you said she was the only one that had a key.
No, that was her storage shed in town. She had a storage shed in town with all her stuff, and she was the only one with a key for that shed. That's where the guns were stored, was in the shed in town.
That's where your son's guns were stored?
Yes. The guns that ended up on the property were in that shed.
All of the guns that ended up on your property where you resided in that camper were originally in a storage shed in town,
Yes,
but somehow they ended up all on your property on the camper.
because deer hunting was coming and she brought them for my son to go deer hunting. That's how they ended up there. Because it was 3 days before gun season. 2 or 3 days before gun season. It was on a Wednesday. and they were getting ready to go deer hunting.
And then they were placed in another shed that you had the key.
That, yes, that a key was on my key ring, yes.
So you,
But I didn't know the guns were in the shed. I wasn't home when the guns were put there.
then how did they get into the shed if you?
I'm assuming Crystal brought them over for my son to go deer hunting.
But if you were the only one with the key,
No, I wasn't, the shed at my house, no, I wasn't the only one with a key.
I wrote it down. You said I was the only one, I was on my key ring.
No, that's not true. I had a key and there was 2 other keys for the lock, because the lock was for the shed and for the chain that went across my driveway down on the end. My son had a key to the shed.
I heard that and I knew that it was his property.
No, the camper is his. The property belongs to me.
40 acres is yours.
Yes,
And he brought the camper for you. So the
yes,
shed is yours.
yes,
The guns in the shed were not yours, but you had the guns in your shed.
yes,
Where
the
the
guns were
key
put in the
shed.
shed, correct. On a Wednesday, and then deer hunting was Saturday. But there was no ammunition for the guns.
Were you and the victim fighting that day?
No. No,
You weren't drinking together at the 10th hole and fighting?
no. No,
Then what happened that day? What happened where she picked you up?
Crystal
from the
was
10th
a
hole?
very depressed person. She was on a lot of medication and she was from Minnesota and she was losing all her medication. She put money in the bank, which I had to, remember when I signed the check for forgery and we got all that settled? Because she had a check that she went to the bank down here in Simon and was gonna deposit because she didn't have an address. So she went down to the bank, Bremer's Bank, isn't it Bremer's Bank down there? And tried to put that check into the bank. And they told her they wouldn't accept it because she didn't have a permanent address. So she went to US Bank, which her and I had an account together. But then she moved back to Minnesota for her medication to a Jeannie, and I can't pronounce her last name's house, and changed her mailing address. That's how Crystal's daughter got the statements for the bank, which she put the money in US Bank, and US Bank wouldn't let her take the money out because she couldn't establish a address.
So again, I don't understand how this happened because here we have a day, okay?
Yes,
Where we have the victim dropping you off at the 10th hole to work.
yes,
And then you
in the
said,
morning. And then she went to the food shelf to help at the food shelf.
can you let me talk,
Yes.
please? And then she dropped you off at the 10th hole
Yes,
and she went back and did whatever she was gonna do that day.
yes,
And then she picked you up from work at the 10th hole. And you're telling me she didn't have any drinks or alcohol.
yes, she did.
So she sat and she drank for a while.
No, she had one drink. She had a Bloody Mary.
She had a Bloody Mary. And she picked you up. Did you have anything to drink that day?
No,
So you didn't drink. She had a drink. She picked you up. She brought you back to the camper. You weren't fighting. There was no negativity between the both of you. You get back to the campsite, to your camper, where you both have resided and lived for a significant period of time. And then all of a sudden, out of nowhere, she grabs a 22, runs in front of the camper or the truck and shoots herself in the head. That's what happened. That's what I'm hearing.
No.
Nothing happened that caused this.
when we were at the 10th hole, there was a girl in there that had black curly hair like Crystal used to have. She used to have long black curly hair. Well, she cut all her hair off and it was pure white. It turned gray. Well, this girl had the same kind of hair that Crystal had, and she had a low cut shirt. And when she went by, Crystal said, look at her hair. And I said, yeah, it's pretty. And I said, she's got a nice cleavage too, because her cleavage was hanging out. And Crystal used to be the same way. Well, the girl next to Crystal turned to her and said, well, I'd like to do something with my hair. So I think one reason was that depressed her, because her hair was cut off and it wasn't what it used to be. Crystal committed suicide more than once. I saved Crystal twice before this. One time she took a bunch of pills when we were living in Burnsville.
It just doesn't make sense. It doesn't make sense.
She was a depressed person.
Respectfully, I think we're getting a little, we're talking about sentencing for having a firearm, and now it seems like the court is moving to trying to investigate.
What he did though, was he messed with the crime scene. By touching a gun, he messed with the crime scene. I'm not trying to go into anything. There were allegations, or there was discussion on whether or not there were facts for a homicide, Mr. Keene, before you were even involved. That was part of a plea deal with the original attorney, that homicide would be forever off the table as part of the plea deal. The court said that can't happen. That's against public interest. That can't occur. So then that was removed as a plea deal. So the court's trying to understand here. I'm trying to get an understanding of how this could even happen. He knew that there was a firearm, a 22.
No, I didn't.
You didn't?
No, I didn't know it was there. The same with the other guns. That day she must have went and got them and took them there.
And with the bears there, you had no clue that there was a 22.
Yes, but the gun was still stored because the bears weren't around anymore.
You just said you didn't know that there was a gun, but yes, you knew that there was a gun, but it was stored somewhere. So there weren't bears there anymore. There's always bears. We're in bear country.
I realize that.
None of these, I'm just saying, Mr. Keene, none of his statements, none of his facts connect. That's what I'm saying. And I'm trying to connect the facts. That's what I'm trying to do. Is he here for a sentencing of homicide? He is not, Mr. Keene. He is here for possessing a firearm as a felon.
Yes, sir.
And that's possessing, is knowing there is a firearm, in your ability to have possession of that firearm. I'm trying to connect the facts. It doesn't make sense if there was no fighting, if there was no negativity, if nothing occurred, and all of a sudden some girl with beautiful black curly hair and huge, delicious looking cleavage, and a statement is made that the woman would go and all of a sudden go home and nothing else occurred. She would grab a 22 and shoot herself in the head in front of her significant other without a statement made. It makes no sense. And then the defendant altered a crime scene. He manipulated a crime scene by taking a gun from a person who apparently, allegedly committed suicide. He took a gun and moved a weapon. He touched evidence. You do not touch a crime scene, whether it is determined a suicide or it is determined to be a homicide, is not for Mr. Scheuer to determine. It is for the police to determine, and they were not given an opportunity to make any determination, and because he altered it. He altered the evidence.
People panic at various times and react in.
Exactly, but they cannot touch evidence in a scene. And here's the thing, again, we're digressing. I'm getting to trying to figure out that day and what happened and why we are here and what I am sentencing for. It is not simply a felon possessing a firearm. And as you stated, and that was part of your argument, there's bears. So you need a gun to protect yourself from bears. And that's why he had the knife, because he needed to protect
No,
himself from
wasn't-
the bears.
The knife, the knife wasn't about the bears. It was just, if you're on a working property, a 40-acre property, you're probably going to carry a knife, have a knife on your property in the country. I mean, cut branches, whatever. Just making a point that although it was a dismissed and read in charge, there's a difference between carrying a knife in town and around people versus having one on your own property.
I get that and I understand that. But again, that's where I'm trying to connect the dots and I'm trying to see where we are because as you can probably gather, this is a very serious case. You're arguing to have him released and just have him sentenced on the case that he was sentenced to, which again was very serious and serious domestic.
My
case.
argument was that since you'd already ordered that one to be consecutive, I was suggesting for a 9 months county sentence, because you'd already in 24 CF 202, you had declared that one to be consecutive to other cases.
Mm-hmm.
So I wasn't suggesting that the court, go from 2 to 3 years in prison as the DOC recommended, or the state's recommendation of 2 years in prison to in essence time served. I was arguing that, an additional 9 months in county jail that was consecutive to 24 CF 202 would be an appropriate sentence for
18 months of jail. And then otherwise we have the recommendation from the state of 2 years in prison and 2 years of extended supervision, or the recommendation of Department of Corrections for 2 to 3 years in prison and 2 to 3 years of extended supervision, and or the maximum possible penalty of up to 5 years in prison and 5 years of extended supervision. When we look at this case, and again, this is why I have to connect the dots and see what happened. And I'm not looking at this as a homicide. I can't do that. That is not what this is. But again, I do have to look at all of the facts.
I want to know why she did it too.
All of the facts as they occurred that day. Every single fact. And I have to determine credibility and whether or not I believe Mr. Scheuer that he says he did not know there was a firearm. And I'm hearing contradictory statements. That's why I ask the questions, Mr. Keene. That's why I ask the questions again in a different way, and then again in a different way. And that's why I asked to connect the dots. Because one time I get one answer, one time I get another answer, when it really is the same question, just asked a little bit in a different way. Stop. So when I'm looking at this case, and originally you're looking at this case, he was charged with 5 crimes, 4 very serious felonies, up to maximum possible penalty of 10 years in prison for those 4 felonies, and a misdemeanor up to 9 months of incarceration for that. Part of this plea agreement, this working the deal out with the state, you got a really good deal here because the agreement called for pleading guilty to the 1 possession of a firearm as a convicted felon, and the rest would be dismissed and read in. So the maximum possible penalty hanging over your head is no longer 40 years and 9 months. It's 10 years. So 5 in, 5 out. So that's a pretty good deal. Considering the facts and all that led to it. Because again, you could have been charged with altering a crime scene. There could have been other things that could have been charged here. But you weren't. And I understand where Mr. Scheuer is coming from that day of stating that the victim killed herself, took her own life that day. Again, I'm trying to wrap my head around what happened and why it happened or how it happened. With the facts I have, I can't. But what I have to wrap my head around is the actual charge that I have in front of me and that conviction, possession of a firearm. Convicted felon. I do believe that you knew that she had that 22. I fully believe you knew she had that 22. I fully believe that you had access to that if you wanted to. You were in a very significant relationship. As you said, you loved her dearly. You seriously loved her dearly. I don't know if you love her now. I don't know if that was your statement, and you're showing emotion as to her death. And I believe your son Brandon when he says that he sees mental health issues in you. I fully believe it. And I've seen, I remember Brandon a little bit from a few years ago. I haven't seen him in front of me, so I'm going to guess that he's done a lot of good things with his life, and he's made changes, and he's doing well. I believe him when he's saying he wants you to do better, Mr. Scheuer. And I believe him when he's saying that he sees a change from when you were raising him and when you were with his mother versus when the divorce occurred and you started drinking again. And that's when it flipped, and that's when the mental health issues, I don't want to say arose, but they grew more intense. And I can see it in the last case in which you were convicted in 24 CF 202 with the individual that you said wasn't your girlfriend, but she thought she was your girlfriend, and that was a domestic abuse incident. It wasn't charged as domestic abuse, but that was a violent act against another woman, against a woman there too, against a person. And mental health issues most likely were involved in that as well. I do believe that you do need assistance, you do need health, you need help, you need someone to provide you with the guidance and the therapy. I don't know how to do it. It's not just AODA, it's not just AA, and it's not just abstaining from alcohol. Whatever happened back in 2003, 2006, and again, then when you started drinking alcohol again, and it started you down a spiraling path, I don't know. Because if you're living on your property, you own 40 acres, and you're living in a tent for a significant amount of time, and then your son has to provide you a camper to live in, and that's through the winters and through, we have hard winters. And if you're living in a camper, it's telling me you're not doing something to get your life on track to be a little bit more stable. I'm glad to hear that you were working at the 10th hole. I don't know if it was full time. I don't know if it was enough to be sustaining or to pay your bills or to have any property or anything other than paying for your 40 acres. But I don't know what occurred that day, and I don't know what happened that day. I don't know if you really did know or have an idea of if your son's other guns were in your shed. You had a key, and if they were placed there on Wednesday, they couldn't have been placed there on that Wednesday, the November 15th. They couldn't have been placed there that day. That would be too coincidental that they were just placed there that day, and then all of a sudden victim killed herself. That would be way coincidental if that's what happened. But I have nothing to show me otherwise. I have nothing to show me that it was a different day. I have nothing to show me that it was that day. But what I do have is what is in front of me, in that I fully believe you were aware that there is a 22, whether or not it was yours or it was hers or whoever it was, you knew it was there. It is a camper, and it was used for the protection of bears, or at least that is the excuse. But again, there are multiple other ways to protect yourself from bears. I've lived here again my whole entire life. I've lived on more than 40 acres growing up my whole life. We have coyotes, we have wolves, we have bears, we have all kinds of other animals that threaten not only our pets and our livestock, but humans and our children. There are other ways to protect yourself than a gun, especially if you know that you cannot use or possess or be in an area that has a firearm unless it is in a locked, contained facility or place. And I don't believe that was. I fully believe you knew that that was there. And the underlying facts of this case are so extremely serious. They're so extremely serious. And everybody, well, maybe not to the full extent, the defense believes that this is a prison case, but this is a prison case, and I don't believe that you can get the help in the community. I think you would be able to get more help in the confines of a prison system. I first have to look at whether or not you can in the community. But I can't see that you can because you are the age that you are. It's been going on since 2003 to 2000 and around 2003, 2006. It's 2025. You haven't engaged in any of this on your own. You were put on probation, and less than 3 days later, you had a serious, significant, violent incident that occurred, and you were revoked. I cannot have the community placed at risk. I cannot put you out on the streets without ensuring that you will engage in some types of treatments, and they will address your mental health issues. They will address your substance abuse issues, and that you will have additional oversight in the end. And that means extended supervision. If I were to do that, I would not be doing my job to the best of my ability. And I would be putting the community at risk, and that is what I need to look at, and the severity of this crime. You have a significant criminal history as well. And that comes into play. So I do believe that prison is appropriate in this matter. So what I'm going to do is I am going to sentence you to 3 years of initial incarceration, 5 years of extended supervision. I will make you eligible for the substance abuse programming after 1 year of incarceration. I'm ordering that while in prison, you engage in mental health treatment and mental health programming. You have a mental health assessment and follow through. You have an AODA assessment and follow through. No contact with victim's family. You have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. If you would like to use any type of weapons, you can hunt. You just cannot use a firearm. You can use a crossbow. You can use a pellet gun. You can use those types of things. You cannot use a firearm. And as far as the knife goes, I'm not the legislature. I didn't write that. Whether or not I think that is an accurate law or how it is written, I can't say. I'm not the legislature. But unfortunately, you cannot even have a knife in a pouch because you're a felon. Cannot even be in a pouch. And this is consecutive to your other sentence. No alcohol, no drugs. So absolute sobriety. continue with mental health once you are released and on extended supervision. Any outstanding fines and fees will be a civil judgment. You're always going to owe them. You can sit more jail time. Ms. Rocca, what am I missing?
Credit.
Jail credit?
Yeah, he had 6 days on the last judgment of conviction in this case.
6 days of jail credit? What else am I missing, Mr. Keen?
I'm Chisora, but he wouldn't be eligible to vote until after his supervision is completed.
Yep, I said that.
Okay.
All right.
Fire.
All right, if there's nothing else, then we are adjourned.
All right, so it is like a little long-winded, but that's okay. It works out for her. I don't mind watching her. I can watch her all day, I think, because I want to hear what she has to say. Critter, he got 3 years in prison, and then I think it was 5 years out of prison, and so in the end, he's got 5 years out of prison, so he'll mess up again and end up back in it. I don't think he's gonna know how to stay out. And I have no faith that he's going to get the services he needs in prison to be able to figure it out. So, but in either way, I found out that in Wisconsin, you can be banned from having a firearm, but you can have a crossbow. So that's odd. In Florida, I don't think you're allowed to have a crossbow if you're banned there. But he signed a plea deal. It was the maximum he could get was 5 years in and 5 years out. And so the 3 years is, in the end, I think she knows in the 5 years that he's out, he's not going to make it. You hate to say that about somebody, but this is the guy that's just not going to make it. I don't know how in the hell he has 40 acres and stays in prison. I couldn't keep up property taxes on 40 acres if I was in prison. I can barely keep up property taxes, and I'm working every day. So I don't know how he does it, but I don't know. People have figured it out. We're gonna go ahead and end it there, and we will come back tomorrow. We'll find something to do tomorrow. Let's jump over to. Oh, we got the ending credits. I added a few new names on it, so make sure to look for your name. And if I messed up your names, let Kimby know, and she'll get it on.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why? I'm totally not angry. I'm not angry.
This is the worst.